Welcome back. We take you back to our top story tonight. The foundation of former President Jacob Zuma announcing today that he will seek private prosecution to have prosecutor Billy Downer removed from his arms deal corruption case. So can a private prosecution then derail the criminal proceedings which are due to begin tomorrow morning? Let's unpack that further. We're joined tonight by OUTA's Head of Legal Affairs, Advocate Stefanie Fick. A very good evening to you, Advocate. Welcome to the program. Is this another trick out of the Stalingrad tactics book of the former president?
Yeah, I think so. I think it's really difficult for our former president and his legal team to accept that apparently that Advocate Billy Downer is going to prosecute this case. I think they have been dealt a bloody nose in so many instances, and I think they think this is the last rabbit that they can pull out of the hat. But I really think it screams of last minute tactics to try and not stand trial. And I think this trial has been coming for so long that I think everybody can see through what they are currently busy doing.
Is it enough grounds, though, for a postponement to be granted tomorrow?
I don't think so. At the end of the day, the minute you are an accused and the state is prosecuting you, there's a whole lot of constitutional rights that come into play. And just as much as an accused person has a right to a speedy trial, a right to legal representations, a right to a fair trial. A speedy trial does not only count in favor of an accused, it also counts in favor of the state. The longer a case takes to go to prosecution, people's memory do not get better. It only gets worse. So I think at some point, and I think we have reached that point, is that our former president and his legal team, and I'm going to assume on advice of his legal team, has tried to push out this trial for too long. And that I don't think a court will grant yet another postponement, because I think that is starting to infringe on the state's right to bring this prosecution. And
without having too much of a scholarly conversation around definitions and the rest of it, private prosecution is a term that's entered the South African lexicon for a few, from 2 years ago, I think now, when AfriForum basically announced that it was going to work with the family of the slain Bafana Bafana player Senzo Meyiwa to pursue that route to bring the people responsible for his death to justice. In this case, let's go through the technicalities which would then allow a person to seek private prosecution.
Well, firstly, in order for you to seek private prosecution, you need to get a nollie prosecute certificate from the state. In other words, that's just a technical term from the state saying, the state is not going to prosecute in this matter. Here is a certificate for you. You can go do it yourself. You might be requested. You need to do the process all by yourself. The costs is all yours, and you might have to also stand security, but getting a knowledge prosecute certificate is not as easy as one would think. In contemplating a private prosecution, you need to think very carefully, because private prosecution isn't there for the taking if you are unhappy with whatever the state is deciding, that you can go for a private prosecution. That is not what that piece of legislation was for. And although we can have, like you put it, I like that word, a scholarly debate about whether, one should look at that legislation and make it more applicable to current circumstances. For now, I am of the opinion that our former president will struggle in getting a knowledge prosecute certificate in order to put this process forward. It is not going to stop the trial that is currently, supposed to start tomorrow. Because one has to remember, private prosecution is very much about more personal rights, if I can put it like that, than public interest rights. So your right to public prosecution is greater than the public interest. And maybe lastly, maybe just put this in context. A lot of crimes are is in terms of the public interest. First and foremost, a lot of things are crime. A lot of acts and omissions are crimes. because, as a community and as, people, it goes against our contra bono mores. So it is like murder and stuff like that. It is against what we believe is right. But then certain crimes is more against you personally, for example, when someone assaults you. So where you are a complainant and it is in your personal capacity that, you can prove damages and so forth, you might be more successful in requesting a knowledge certificate and then privately prosecute. Yeah.
Okay, so that's the private prosecution aspect, but the Jacob Zuma Foundation has also said that they've now filed their reconsideration application to the President of the Supreme Court, that's Mandi Samaya in Bloemfontein, where they are fighting the participation of Advocate Billy Downer in the corruption trial on that front as well. Could that then influence the start of the trial tomorrow?
I don't think so. I mean, one can never, with this trial, I think, every turn there's another surprise. And I think it just smells of desperation, the fact that, why are they struggling so hard in order to stop this trial from starting? I've said already, and I think a lot of people will think, but you've got so many constitutional rights the minute you are an accused, and you're going to be part of that trial. So, as the trial goes along, you will have the opportunity to also sort of say, and in certain instances, I want to say, prove, but I'm putting this in brackets because the state has to prove a case against you, but prove that you are innocent. I just do not understand this absolute fight for this trial to start. But whether that will have an influence will most probably lie with, the judge tomorrow. But in my opinion, I don't think so. I think they have tried and they've really gone out of their way in order to stop this trial. And I think that they have not succeeded. And I don't think they will succeed tomorrow.
Let's end with the NPA then. I know that when the recusal application was brought before the High Court, Judge Piet Koen, I believe it was, basically threw it out when the former president had argued that Advocate Billy Downer was biased because he'd leaked allegedly details to a journalist, private medical details of the former president in the case. So that was then dealt with at the time. But now that Billy Downer is back working on this case, is it really worth it for the NPA to have a situation where the prosecutor is such a central figure at a personal level as part of the case? Why not opt for someone else of his experience to proceed and eliminate the element of drama?
It's also a question of, I think the question starts with what is your definition of getting personally involved. I think to a certain level, prosecution is always objective, or it should be, because it's not personal. And I cannot fathom, that a prosecutor will get so personally vested in a case, except for professional sort of personal investment, because prosecutors work extremely hard to prosecute on behalf of the public, because you are fighting on behalf of the public on a platform where you are trying to prove to a court that someone is guilty of a crime. Now, there must be some personal investment because it's your time and your effort and your professionalism. But I do think one forgets that a prosecutor has only got so much influence. So it's very important that a prosecutor knows the case inside out, because a prosecutor needs to know, obviously, the law, needs to know what evidence they're going to lead. But at the end, it's the court that is the objective viewer that needs to make objective decisions. Our constitution, and therefore in our democratic sort of environment, it makes it possible also for an accused to attack whatever, the state is putting forward. The court is not going to listen to the state because it's this advocate Billy Downer. The court is going to listen to facts that is presented for him. And even though one has to argue that at some point, it is about personally for advocate Downer, which I doubt. I think it really it is what you think to be, or what you want the people outside or the media wants to believe what personal involvement is. But if advocate from the state side just puts the facts before court, I mean, they're not going to address the court and try to convince the court of something. They are going to put facts. They're going to lead evidence of witnesses. So to what extent, I think our former president and his legal team is scared that this bias is going to influence the trial is I don't know. And I do think that we've started this rhetoric of this personal involvement in order to try and get this advocate removed, which I think is not grounded in fact.
Advocate Stefanie Fick, Head of Legal Affairs at OUTA, good to have your time. Thank you.